Thank you very much, Mr. Clerk. It is reported that the quorum does exist for the Finance and Public Accounts Committee to commence business. Those in favor, please say aye. And those not in favor, please say no. The ayes have it. Thank you very much, honorable members, subject matter specialists, officials from Pura. Once more, you are welcome to today's sitting. As indicated yesterday, that you reappear before the committee for the consideration of the report that was presented yesterday. Here we are look into the report that's supposed to be considered by the committee. Before we do so, the agenda that we have before us is being circulated to members. Yes, the subject matter specialist. Honorable members, you can go through the agenda. Even you want to propose any amendment to that effect, you can do so. We have about 5 agenda items. Then, in the absence of no other amendment to the agenda, can somebody move that we adopt the agenda? Honorable Fofana. Any seconder? Honorable Chan. It has been moved and seconded that the agenda for today's sitting be adopted without amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. So on the agenda being adopted, we have opening prayers, which we have done already, administration of affirmations by the clerk, except if a new person is supposed to give evidence other than the ones that were sworn and they were given evidence yesterday. Other than that, all those who gave the affirmation are not obliged to do so. I'm supposed to remind you that you are still under oath. Yes. If I'm asking whether Pura have agenda yet. Okay. Now, we have administrative of affirmations, consideration of annual activity report, consideration of annual activity reports and audited financial statement by Pura, and any other business, then closing remarks. Now, this is the agenda that we have adopted, and we did the first item, that is the opening prayers, and then the administration of affirmation by the clerk. I did indicate, except for a new member who's supposed to give evidence. Other than that, all others who were here and then they gave their affirmations would still be considered under oath and need not to take any oath for today. Then any other business and then closing remarks. Now that the agenda is adopted, I'm not sure if I think we still have some new members. We can do the introduction. I start with the honorable members, then subject matter specialists, and then Pura officials. My humble self, I'm Honorable Alhaji Dabo, the chairperson of the committee. that all? May proceed. I've just been told that we have new witnesses who are supposed to take their affirmation. Then I will ask the club to administer the new members or the new officials who were not here yesterday. So, the DG, I think it is save time. What we want to do is that if there are people who may give evidence at any point in time where necessary, I think it's better we do the administration of the affirmation once and for all. If, for instance, there's a need for you to come in, then that means you are already on the oath. So we don't want to be interrupting for the person to be taking the oath and coming in again. So yeah, that's why we want to do it once and for all. Okay. will speak the whole truth. I, Salih Kuba, I affirm that I will speak the truth. Nothing but I, Muslim, hereby affirm that nothing but Thank you very much, Mr. Clerk. Honorable members, the subject matter specialists, officials from Pura. As earlier on indicated, we are here today to consider the report of Pura as presented yesterday. Yesterday, we received the reports of Pura, the activity report and the audited financial statements and the management letter. The committee reviewed the said reports. The appointed auditors of Pura for the financial statement for the year ended 31st December 2020, they have expressed a true and fair opinion on the financial performance of Pura and its cash flows for the year ended in accordance with the general accepted auditing financial principles and have been properly prepared in accordance with the Companies Act 2013 as well as Pura's Act 2021. On the basis of the said opinion, the committee will now look into the report as presented for possible consideration or otherwise. In trying to do so, the committee looked into the observations and concerns that were actually mentioned in the report. And before the committee can go further for possible consideration, we need clarifications on those issues and concerns that were raised. And therefore, I will now open the floor for the honorable members to interject in order to seek clarification on those issues and concerns that were highlighted by the auditor. Honorable members, the floor is open to you. Honorable Fofana.
Thank you very much, Mr. Chair. And good morning to everyone. I would refer the management of Pura to the audited financial statements, page 22. 22. Page 22 of the audited financial statements. That should be just after the activity report. Notes 2 on the revenue. During the year on the review, we've realized that your revenue have increased significantly from 76 million in 2019 to 128 million in 2020. In as much as the committee would like to commend you for a tremendous performance, but again, we would like to know what were the main drivers? Two components of the revenues were highlighted, which is one, the penalty fees, which have increased from 310,000 to over 13.3 million. And secondly, the Pura International Gateway Fund was also for the first time highlighted in your financial statements. So we'll refer, Mr. Chair,
Yes.
I would, with your permission, I will refer that question to the finance and admin manager to tell us what was the reason for the high penalties that were charged to the subscribers, and if possible, the list of the defaulters as well, and also give the FPAC committee a brief overview of the Pura International Gateway Funds. Thank you.
Can you be specific? We take the questions one by one. Let's start.
What was the main reason responsible for the progressive drivers in the increment of the revenues or the fees from penalties from 310,000 to over 13.3 million?
Okay, good morning, Mr. Chair and fellow members of the committee, FPAC committee. Relating to the penalty fees, Pura has developed some regulations concerning about the operation of the operators. So this penalty fee, which increased from 310,000 to 13 million, is relating to AfriCell. AfriCell, I think it was they were unauthorized to terminate calls by then, and SIM card registration also. It's all related to those things. So AfriCell was in fault, and some operators were also in fault. Gamcell also were in fault. So that's why we imposed those penalties on them, and they pay it. Thank you.
Yeah, you said that related to the charges that were levied on AfriCell for
unauthorized termination of international calls.
Then how much was involved in that for AfriCell?
Okay. Maybe that one we can give you the information when tomorrow. We can forward the information tomorrow for those one for the breakdown of the 13 million.
For the 13 million.
Yeah, 13 million. Yeah, we can give you the breakdown tomorrow. Even today, we can even bring it today. After from here, we can just come on. We can bring it today or tomorrow morning.
Can bring it today.
Either today or tomorrow morning. Yeah, for the breakdown of that.
Okay.
Today, yeah. You can.
Mr. Chair, with your permission,
Yeah.
We aren't expecting the breakdown, but we can call to the finance team back there, and they can send us the breakdown. So we can give you whilst the meeting is still on.
Oh, that's
it composed. But if you allow me just to add to what he has stated, these particular penalty fees are indeterminable because they arise as a result of somebody infringing the rules or regulations of the authority. So in 1 year, you can have nothing. In another year, you can have millions. It depends on when people fail to adhere to the rules and regulations of the authority. So that's why you can have big fluctuations, because they cannot be determined by a budget. Thank you.
I think in the activity report, which is related to this, before Honorable Fofana will proceed, it is indicated in page 30. Page 30 under AfriCell, it's a continuation under AfriCell. By the said legal notice, the authority instructed AfriCell to adhere to the current blocking framework of suspected fraudulent numbers, and further warned that failure to comply will result to enforcement action taken against AfriCell in amount of $50,000 for each number block per day. in violation of the governing framework. After the legal notice conveying the authorities last sworn into Afrisel, the authority, having conducted an investigation, noted with regret that Afrisel failed to comply with the prevailing framework and have continued unilateral blocking other operators' numbers from accessing their network. Having weighed the totality of the facts surrounding this issue, the authority determined the following action against Afrisel, that for the payment of the fine of $550,000. So I would like to know whether that is in connection to the said increment that honorable member is trying to ask.
Okay, thank you, Honorable Chair. This 550 is part of those, that 30 million is included in this one. But we can give you the breakdown when we call at the office. We will give you the breakdown before the close of this session. Thank you.
The second part of your question.
Honorable Chair, if you permit me, I will just make a supplementary question to that before moving on to the second part. The call termination for Afrisel, can we know the period? The period. The period under review. The period of the investigation as well. We would be interested in that. The period it have covered. And for how long it have been going on, and when did you realize it? If that can be provided, it will help. Mr. Chair. Okay. We'll be on the same page again. That will be page 22 of the audited financial statements. And for the first time, we've realized that the Pura International Gateway funds also were received. Nothing was there for 2019, but in 2020, an excess of 19 million was received. Can I continue? Yeah, the question, Mr. Chair, with your permission, would still go to the Finance and Admin Director. If you can help us to know, specifically what the Pura International Gateway funds entail.
Thank you, Honorable Member. I will pass over to the Director of ICT to help you clarify what it is about and how it came about. Thank you.
Thank you very much, honorable members. If you refer to page 52 of the activity report of Pura, which is section 1.1.1, page 32.
52 of which one?
32.
The financial or
activity report.
activity?
32.
Page 32, item 1.1.1. This relates to the international gateway. Prior to 2020, all international calls coming in and out of the country was handled by a gateway managed by Gantel. In 2019, at the later part, that's in September, the government of the Gambia gave authorization or a license for the international voice gateway to be liberalized. And Afrisel and QCell were issued an international voice gateway license in September and October of 2019. In 2020, the other operators were issued license, namely Gamcell, Gamtel, and Comium. So which means, as far as the international voice gateway is concerned, all operators have been issued licenses to terminate calls in and out of the country. And one of the conditions of the government was that if the operators were to be allowed to terminate voice traffic into the country, a monitoring tool needs to be in place so that we can be able to know and capture the exact amount of traffic coming in and out of the country. Furthermore, the Ministry of Finance came up with a framework whereby all revenue that is accrued from the International Voice Gateway has to be distributed amongst all the key stakeholders. From the 100% revenue that is accrued from the International Voice Gateway, 50% of that revenue should go back to the operators. 30% should be taken by the Ministry of Finance, 5% by the Ministry of Communication for their ICT agency. 5% of that revenue should be taken by the National Health Insurance Services, and 5% to GAMTEL, and 5% to Pura for the management of the International Voice Gateway license. So, as a result, the revenue that you are seeing in the books, which translates to about 13,000, is it, Paul? 19,000, 19 million is part of this revenue stream. And just to add, 30% translates to about $120 million, which has been accrued and sent to the Ministry of Finance. So this is what we are talking about. Thank you very much. And the contract was signed by the Ministry of Finance in February 2020. Thank you very much, honorable members.
Honorable Fofora. You're done
That's in order, Mr. Chair.
for that question.
For that question, thank you. Thank you.
Any honorable member? Jai?
No, I think actually I don't have anything because I'm really impressed with their finances. Actually, I'm just a bit concerned about the liquidity. But then again, if you look at it in financial terms, maybe.
Are you using the mic?
No, I don't normally use the mic because I thought my voice was loud enough. Okay.
Yeah,
Okay.
the video will need it.
No, I thought, no, I said, I don't think, all I can say is that I'm quite impressed with their financial management. And I think, having looked at the liquidity, it went down a bit, but then again, there might have been some investments that were done, I would assume. But then I would rather you have assets than have liquid in cash. So that's all I can say. Having looked at it yesterday, I would believe that if all institutions were judiciously, financially managed like Pura, I think we would have been, it would have been better. But then again, if they can manage to increase their revenue by just incurring charges to Africell, what is stopping them from charging NAWEC as well? Because we've all seen the, how NAWEC have been operating, and I think they flawed all the laws that governs them. So I think you should also ensure that they adhere, because government have invested a lot in NAWEC. In 2016, I remember going to the ECOWAS Parliament and Gambia, 2017, reporting that we received, I think, about $34 million for NAWEC, and the project was successfully implemented. For me, I wonder what success means in that case, because I've not seen any success in NAWEC. So I think you being the governing body, you should look into it and see what is wrong, and if need be, charge them. If they know that they are going to lose something by not giving us the right services, then they might up their game.
Is that all?
Yes, thank you.
Thank you, Honorable Njai. Any other honorable member? yeah, we are still on issues surrounding the income, then if we don't have issue on that, or on the Wolfofana?
It doesn't relate to the income anymore.
Okay.
You might like to exhaust that before we move.
We have not, or if we have exhausted issues surrounding income, can we move to the other areas of concern that were highlighted? That's the issues surrounding the expenses, the trade receivables that were highlighted in the report. Honorable members? Yeah.
Yes, again, as the report says, I mean, if you are not paid on time, it affects your operations, and the amount of debt outstanding, I mean, it's just too much. I think we should do something to support them to make sure that they receive, especially, I mean, 57 million is a lot of money. 25 million, 82, and I believe that these people because now they don't have postpaid. You prepay before you are given electricity. So it's not that people are owing them. People pay, and even the electricity that you pay for, you don't have it. So they have the resources, I think, if it is well managed. Gamtel, probably due to poor management, because Gamtel should have done a lot more, because I think all A's monies are paid to Gamtel, correct me if I'm mistaken. So even with, if Africell can afford to pay, I think Gamcell, being the national provider, can also. So you being their oversight body should ensure that they do things properly, because people spend a lot, and Gambia has the highest rate of telecoms in the region. If I go to Abuja, if I spend $500, I can use it for 2 weeks. If I spend $1,000 in Gambia, it will not even last for 3 days. So I think we should also look into that. That's the trade. I've already mentioned the liquidity. And again, if it wasn't managed properly, it could have affected your liquidity. I've seen the liquidity ratio drop. Maybe this might also be an issue that affected it. I mentioned that it might have been investment, but looking at this now, it might also be one of the cases.
Honorable, yeah, just to save time, the general comments can come later. I think we have, yeah, what we want to do for now is for clarifications in the event. Yeah, there are issues that were raised here, so we want to seek clarification from them. Was it a question or a remark? Okay. Yeah. So can you properly put forward your question so that yeah. Yeah, so to whom do you direct that question to? DG?
Yes. Thank you, honorable member. I think your question is a valid one and credible one. We want to reiterate that this report is for 2020. So you will see a marked difference between what happened in 2020 and what happened in 2021. The receivables that you are seeing here includes a lot of money owed by not only operators, but as he said, Gamtel and NAWEC. And during 2021, we have ensured that they made payments and signed agreements which they are honoring. If we go currently now, you'll find out that we had collected over 70 million from Comium alone for debts that they owed to the institution and to government. But also we have collected more than 10 million from NAWEC and another 10 million from Gamtel. So we have stepped up our game this past year. It's not reflected because this is the accounts of 2020. But honorable members can take note, and when we come for the 2021 report, you will see the difference in terms of our receivables and what we have done. Because we believe that as the regulator, we should not have a discrimination between the public sectors and the private sectors. And as he said, we cannot just go after the private sector and leave the public sector. So this has been taken on board, and we have stepped up our game to ensure that their liabilities are paid and that they are paid on time. And failure, we will be doing enforcement like we do with the private sector. The only difficulty is that we must note that when it comes to NAWEC being a monopoly and the only provider in the country, we have done with Comium what we can't do with NAWEC, which is shut it down. Because if you shut down NAWEC, the entire country has no power alternative. So you have to find a way to make them feel the pinch and make them realize that they have to own up and do their responsibility, but in the way that you can do it with a private organization where you have alternatives. You cannot do the same with a public entity without any alternative. So we will ensure that we keep pursuing and making sure that they own up to their liabilities and pay it on time. And this is an assurance we give this body, which we will validate in our subsequent reports. And you will see the diminishing of the amounts that are outstanding due from public institutions. Thank you.
It is noted that for both NAWEC and Gamtel, they are owing about $82,703,563. It's representing about 98.93%. To break that down, NAWEC is 57,324,803, and Gamtel is 25,378,755. They are saying they are public institutions, they cannot be shut down. You need to draw mechanism to see how best they can possibly cooperate for possible recovery. What plan do you have in mind in order to do that effectively, so that, as you are saying, the public also would not be affected if they defaulted?
Thank you, sir. As I stated, because of the report being outdated and the current situation, we have managed to bring them to bear and giving them deadlines in which they have honored by paying deposits of 10 million each towards Pura and sign monthly payment repayments to liquidate the arrears. And these monthly payments have been coming in regularly from both NAWEC and Gamtel. But we still want to ensure that in order for this not to be continuing to appear on our books, that once they liquidate, they stay on board in terms of what dues they are to pay annually. So we have a framework, we have an agreement with them, a repayment agreement, and which they are honoring, and we ensure that in order to make good, they made an upfront payment of $10 million each towards that debt. So that's why I'm saying if we give you an update of the current situation, it will be a different. But we still need to pursue Gamtel because what they have explained is that they have huge investment that they have undertaking and they need time to recover their money. But we are even trying to see an asset swap mechanism whereby they can have a trade-off with Pura and we can liquidate this debt. And we have taken it to higher levels whereby our legal people are discussing to see how we can do this. So these are some of the mechanisms we are putting into place. But all their current dues are being paid. The arrears is being paid in installments.
Give us the time frame of that payment agreement.
Okay, let me see if our finance manager remembers, but I thought it was for 1 year. Finance director, agreements.
Okay, thank you. Concerning relation to NAWEC every month they are paying 1 million towards the regulatory fee in the areas. Now it has gone down now to 18 million from that 25 million that you see. It's gone down to 18 million now. Every month they pay 1 million to Pura. Towards the areas.
Pay 6 million.
Yeah, for their current bill, they paid it already. They pay a lump sum money for their current bills.
Every month they pay 1 million. And when did they start to do the payment? That's what.
In May.
May of which year?
2022.
2022.
Yeah.
May 2022.
Yeah.
They start paying 1 million per month.
Yeah.
It's going to take
No, they paid an initial deposit of 10 million upfront, and then they pay 1 million every month. But they also have a bill of 6 million, which we increased to 8 million per month on their current regulation, which they are paying in full per annum, and they have not been failing on that. They paid it upfront. So there is no more allowing them liabilities to be accumulated. We've stepped up our game on that.
Honorable Fofana.
Thank you, Mr. Chair. The question would go back to the receivables again. And it's rather unfortunate that initially it went so high, although it's refreshing to note that, I mean, you've come up with mechanisms. But the committee would like to know, what is your policy when it comes to revenue? Because no organization survives without income. What policy do you have around it? Let's call it sales. Of course, you don't have a physical item that you are selling, but you are generating revenue out of those services that you are providing as a regulatory agency. So what policy do you have in place? Because it is only that policy that can help us prospectively to avoid what is happening now.
Thank you, Honorable. Honorable, the conundrum that, by the way, I'm new to Pura, just 1 year in Pura, but just to give you a perspective, the institution didn't have a strategic plan in place for the last 3 years. And I think policy development starts from the strategy. You need to have a strategic plan in order to know what your policy guidelines are and what revenue you're going to have. Under normal circumstances, multi-sector regulators are responsible for licensing and any regulatory fee collections in other institutions. Just to cite the case of Pura in Rwanda, all licenses are issued by the regulatory authority and collected, the revenue are collected, so to speak, as well. Unfortunately, in the case of Pura in Gambia, we found the law and the acts making the government the collector of the revenue for license, and Pura on the regulatory fees and so on and so forth. So our revenue base is very small. We have a lot to do in order to regulate the institutions that we regulate. We need to have the capacity and the equipment. And these are the things that we are trying to cover with our new strategic plan. And we are hoping that the revision of the act which we are undertaking right now, both the ICT Act and the Pura Act are being revised, that the revenue base will marry what we have in our strategy to ensure that the regulatory authority is mandated and resourced enough to carry out its mandate without any hiccups in terms of either personnel or equipment necessary. This is our policy guideline that we are working on. We want to strategize to ensure that our revenue is secure and comes directly to the authority so that we don't need to get resources either from government or other sectors in order to carry out our regulatory function.
Okay, thank you. If you go to page 22 of the audited financial statements, and you look at the revenue generating activities of Pura, from regulatory fees, you have application fees, you have regulatory fees for radio station, type approved fees, penalties, petroleum fees application, numbering fees, petroleum levy fees, Pura International Gateway. And I believe, even, let's take it on a simple term, even if I should have my corner shop today, the first thing I would do is to have a policy as to how do I do my sales. Do I do it on cash basis, 100%, or do I do it on credit basis? But if I don't have a policy towards sales and revenue, then tomorrow, whoever owes me and doesn't come back, I will just have myself to blame. So the question would come back. That has nothing to do with the act. That is a managerial issue. The management of Pura should have a policy towards income, how they generate it. Is it on upfront payments? Is it on quarterly basis? Will it be received in areas? That is important, because if at all such things are in place, and then the other people, your service providers know that these are managerial issues, and if we default, so and so sanctions will be in place, you might not even have an issue with NAWEC. You have an issue with NAWEC because they were able to benefit from the service before paying it. So what is the comprehensive policy surrounding your income generating capacity?
Thank you. Thank you very much. Okay, I get to understand more your question angle in terms of policy. Our policy is based on our expenditure plans as well. We have payment plans that are in place with institutions that are on quarterly basis. There are certain revenue base that we collect on quarterly basis. And we look at it also in what are we going to spend on in terms of our quarterly flow, cash flow. These are part of the things that came either from the Act. That's why I reference you to the Act, because there are some that are governed by the Act, which allows you to pay either quarterly or annually. There are some, like, for example, regulatory fees. Because of the amounts involved, usually we collect it on a quarterly basis. The application fees are paid upfront. We don't give you any responsibility to operate. If you are applying, whereas you're applying, the payment has to come upfront. When you pay is when we process your application. So these are all in also the regulatory fees for radio station type approvals are also granted only when you pay. The payment is upfront. Each one of them has a rule based on what the Act says and what our collection methodology is. So as you say, we needed to be specific and strict in adhering to this. What you have found is that in the past, we have not been ensuring that these things are abided by 100%, because then NAWEC would not have been in arrears. Their payments should have come up front in the period of the year in the quarterly basis. But we are now ensuring that going forward, that is not the case. If the rule says that you have to pay quarterly upfront, you pay quarterly upfront.
I just do have a last question on the receivables before moving. That point is very important because if you go to page 26 of your audited financial statements, page 26, if you look at the provision for doubtful debts, you realize that in 2019 it was 11 million and in 2020 it was 16 million, which means over the year it have increased by almost 5.5 million. So with the guidance of the chair, I would be asking 3 questions. All of them will be directed to the finance manager. The first one is, since the CEO have said that in 2021 and 2022, you've made some significant recoveries with regards to the outstanding debts from NAWEC and GAMTEL. Now, what happens to the provision of 16 million that was done in 2020? That's A. And then B, there was a provision of 11 million in the year 2019. And it is indicated in the financial statement that that 11 million was in respect to private companies. Can we have a list of those private companies? The list of the private companies and how much was provided as what? Doubtful debts in respect to them, and what was the justification. But to start it, let's deal with the issue of GAMTEL and NAWEC, and to the finance and admin manager. Since you've made significant recoveries, what happened to the 16 million that was done? It is one thing to make a provision and another thing to completely write it off. You can make a provision, but that shouldn't stop you from going after it. If you receive it, it becomes a surplus. So now, what happens to the initial provision that was done?
Okay, thank you. The provision of 11 million, it was relating to NAVEC and this in Gamtel. But for the NAVEC one, it's just a provision. But afterwards,
sorry, Chair, I want to interject. That is inaccurate in accordance with the financial statements.
Yeah.
The 11 million was in respect of 2011, and it was clearly stated that it was for private companies. Government institutions were followed up. Can you check it clearly?
no, if you check it, the private companies are not, let me check for the 20, 38, 38, yeah. Yeah. Okay. For page 38, if you see it, it was GEG. GEG was the one responsible to operate the Mandinari power plant.
GEG?
Yeah, GEG. Yeah.
Is that NAVEC or a private company?
It was a private company.
It was so not NAVEC?
Yeah, it was for 2019.
2019.
Yeah, it was for the private companies, GEG. And then iLink was also ISP that was issued a license, but it didn't operate. So it was written. And Lennox also was a private company also that was issued a license also, and it didn't roll out also, and it was accruing regulatory fees. And also Thomas Global also, they were issued license for ISP also, and they didn't roll out. So these are all accrued regulatory fees areas to them. That was provided for in 2019 as provision for doubtful debts.
The question is,
Yes.
do you recognize income before earning it? Because if you roll out a license, you would only recognize the income in your books if at all it is effective. So how did you end up writing receivables of over $10 million in the name of GEG when it wasn't rolled out? What I want to ask is, was this an actual debt? Were they in operations? GEG?
Yes. GG was in operation. Basi was one. The one that was operating the Mandinari power plant.
Okay, so
Brikama power plant. Sorry, Brikama power plant.
So
Yeah.
the issue of license was rolled out, but it didn't operate. It didn't stand in his case. Not so.
Which one?
10 GEG.
GG
10 million.
10 million.
So, Mr. Chair, we might like to know how it was substantiated by the board that a significant amount of over 10.6 million was declared as bad debt and subsequently written off from the books. Because in the following year, you can realize that it was written off from the books. So the committee might like to know, how did the board arrive at that?
Direct a question.
To the board chair now, because the board should be responsible for the provision in
Default. Operations now. It's no more in operations.
Pardon?
GG is no more in operations now.
GG.
And they this is defaulted and they closed now. And they transfer. I think it was an agreement that after they operate for some years, they will transfer the assets to NAVEC.
Okay?
Yeah.
Because if NAVEC was to take over GEG, there should be a clause on dissolution. The assets and liabilities, who inherits them? So we want to know, how did the board reach to the conclusion that they have exhausted all avenues of recovering what was rightfully theirs before they...
Thank you, Honorable Member. Maybe I refer to the Director General. I don't think the board ever wrote it off, but you can explain.
Thank you. Honorable members, I think I'll try to give you a background. As you rightly pointed out, when something is written off, it has to be given a policy document that gives the right to have it written off. GEG, as he has rightfully stated, has stopped without operating and getting any revenue. They ceased to operate. and the liability. Hence, in the financial statements in 2020, the institution decided to take it off the books because of the company being dissolved. The alternative would be to chase it through NAWEC. But unless NAWEC assumes the liabilities of GEG, that is not seen to be effective. If the company had operated and had revenues base that was collections were made, then it would be vital to collect. As you know, for example, just to give you a current situation, we have issued license to operators for GSM or others. They have a liability to pay once we have issued the license. But they can stagger the payment in quarterly basis. If this company fails to operate at all, you have very hardly any basis that you can to go after them in a court of law because they are already dissolved. And I think that was the basis on which they decided that they will leave this charge out of the books in future years. And I think the auditors were very instrumental in ensuring that the institution has provisions, because in the past they didn't even provide for doubtful debts. And some of the collections were doubtful, including the one for Comium, because they didn't upgrade and revenue base was going down. But since we've put some institutional mechanisms now in place, we were able to collect those money. And therefore, in the subsequent period, you'll see a reversal of reinstatement of a doubtful debt that was provided for. So it will not be written off in that case.
Honorable Chair. Particular with the issue of GEG.
The auditor, can you clarify that issue?
Yes, thank you, Mr. Chair. In 2020, but what I want to assure you is basic accounting. When recovery is doubtful, you provide. You provide and chase. You chase and chase. When you're tired, you write off. I think there is one specific mention the Honorable made, which is very spot on. The director's responsibility for these amounts to be written off. So this should have been captured in the board minutes. Maybe that was not done. When you look at the board minutes, you wouldn't have seen that. But those are things which are board responsibility which they should have assumed. But you cannot also leave accounts in provision hanging when you know you wouldn't be able to recover it. So you have to write them off. That is why the write-off. Another point is the issue of provisioning. The accounting policy is currently being revised. We had issues with them regarding provision. Not only Pura, but most government institutions don't have a very rigid provisioning policy because they relate to government. So even us as auditors, we have difficulty dealing with that. But we push to ensure that the amounts we think are doubtful are provided gradually. So that is what we do, to push for gradual provision. But they've assured us they are working on a provisioning policy because they are revising the accounting manual, which is currently in progress, which we will review before we finalize our 2021 audits.
Honorable Chair, I would give the floor back to you, but would only like to advise that we make further follow-ups on the issue of GEG in particular.
Okay.
Thank you.
Before, Honorable Njai, I think the chair or the DG can answer that question. Whether you have policy on debt recovery, mention, or that you came new but found out that there is no strategic plan as at now and you are working on one. In the absence of that in general, do you have policy on debt recovery and write-offs?
Thank you, Mr. Chair. Mr. Chair, we have developed the strategic plan and it was approved by the board within 6 months. It's already in place with a performance management framework and a monitoring tool to ensure the implementation of the activities. Ensure that they match best practice currently.
Yeah, and that one has clearly captured the issue of debt recovery and write-offs.
Yeah, it has all the policy documents that we require, and they are being updated.
Can you make that available to the committee?
Yeah, we can share the strategic plan and the performance framework. The policy documents are currently under review because the business strategic plan was just recently approved by the board. So we are in that process now to update our policy documents to match what we have in our strategy. But we will share the strategic plan with you.
Okay. Honorable Njai. Okay. Oh, thank you. Now, the other issues that were highlighted and raised as concerns in the reports, issues surrounding the management letter. Honorable members, you can go through those issues that were raised and then ask questions for clarification.
On to the genesis of this account in the books of Pura, an amount of $129,908,577 is reported in notes to the accounts on page 30. Which we have the government of the Gambia 908,577. ICT is nil agency, right? And then GAMCEL is also nil, and we have a total of 129. So can they explain how this came in anyway?
To whom do you direct that question to?
The finance director.
Finance director, do you get her right?
The honorable member, I think the gateway and the revenue total, how it arrived at, and the sharing ratio that Pura gets 5% of the international gateway, and that is the share we have. He can explain it again if you need it.
Sorry, can I intervene? Honorable Chair, can I intervene? It's on.
There's a need.
Of course, there is a need.
For the IT director to still go over.
No, not how the revenue was generated, but the issue is, if you look at the notes on page 30, you won't see it being reflective in any other place. So we want to know the genesis of it.
Is it in relation to the question?
If the notes come,
Honorable Fofana?
yes, the same question.
The question posed by
Absolutely.
Honorable Cham?
Yes.
And the DG referred the question to the IT director, and he did say at least that was part of the answer given by the IT director, but
Yeah,
if still it's
129.
not clear, he can go over that answer that he gave initially, which is in relation to Honorable Cham's question. Yes, go on.
Thank you, Mr. Chair and honorable members. The note relates to discuss and disclose related parties and their transactions and their balances. So this note summarizes the transactions and balances with all related parties. Pura being a government institution, the related parties relate to central government and all other government institutions that it has transactions with. In this case, you're trying to summarize the transactions that they have. That is why you have the this international gateway. When you look at it, you will see purchases of goods and services, sale of goods and services, and orders, receivables, payables, everything. It summarizes the transactions and balances with all related parties. And the related parties are government and government agencies, senior management and directors. So this node captures those. You will not see it. It may relate to other nodes, but this is a separate disclosure which is made in every financial statement.
That helps, right? Okay. Thank you.
Thank you. Yeah, we are on the management later, the issues that were highlighted under the management later. So I think we want to be guided. We have a guide that is guiding us. Oh, it's a follow-up. Okay, you could go ahead. If you are asking questions, please make sure you use the mic, because otherwise you will not be heard.
Thank you very much, Honorable. The honorable member wants to know how side to the Gambia needs to be terminated on the mobile networks or fixed lines of the Gambian populace. So what we do is, for any minute of call that is terminated into the Gambia, we charge them 32 US cents. And that's the thing. So if you generate 10 million minutes at the end of the month, you can do the maths and just multiply 10 million minutes times 32 cents, and then you know the value. Now, assuming that is $10 million, that is just as an assumption that you generate. The government of the Gambia has said that out of that $10 million that has been generated from these voice calls that are coming into the country, 50% of that revenue should be sent back to the operators, because they are the ones who are actually the owners. Because the reason why, for a call to come from the US, it has to be terminated on a mobile operator. Hence, that mobile operator needs to have 50% of that revenue. That is to say, $5 million should go to the operators. Now, out of this other $5 million that is left, the government of the Gambia has said that 30% of that $5 million should be sent to the Ministry of Finance. 5% out of that $5 million should be sent to the National ICT Agency. Another 5% should be sent to Pura for the management of the international gateway tool. 5% should go to GAMTEL, and 5% should go to the national insurance. So this is how it works.
Okay, can you use the mic?
Okay, then. Now that it is liberalized and they are getting their fair share, so how does that impact the telephone charges locally?
Okay, thank you very much.
And what is the rationale behind giving them those percentage of the proceeds?
Okay, I will hand over the floor to the director who is responsible for tariff regulations.
In the telephone business value chain, there are different components. You have the international revenue streams, you also have the local revenue streams. And the international gateway relates to international revenue that's coming to the country. And there are also some payments operators also need to do when calls are made to other countries. So in terms of IC tariff in the Gambia, we have a liberal sector. Where there is monopoly, there is no price regulation, and when there is competition, it's left to market forces. Just like the commodity prices, the price of rice in other places. So that is standard across all over the countries in the world. Now, what happened is that in the Gambia, prior to the gateway being liberalized, and before you have the internet connectivity, direct internet connectivity, we are relying on Senegal. So we will get our internet services from Senegal at wholesale level. Now, what happened is that the prices of internet was very high, and also voice prices were about $3 per minute, somewhere up to $250, $2.50 per minute. It was on a downward spiral, but unfortunately, towards the end of 2020 or thereabout, government also introduced the sports levy. Once the sports levy was introduced, mobile operators also increased their tariff, because the moment you have a levy, the business will not absorb that cost for you. It has to transfer the cost to the consumers. So this is what has led to the slight increase in the price of voice telephony. But it was on a downward spiral from 2015 downward. It was going down gradually. Now, but for the internet, we still have challenges in that, as Honorable Njai said, in Nigeria, when you buy data, is far cheaper than the Gambia, which is a fair point. We recognize that, and it's a problem. But it has a historical perspective. The issue of this gateway and other things. Before we got our submarine cable, we had it about in 2012. Then Senegal had it in 1995. So somebody who had a gateway in submarine cable in 1995 has almost paid everything. Gambia had this in 2012. Even after 2012, operators were promised to take a loan. They took a loan to be part of the consortium. And government reneged, and they refused to give an international fund, because their projection was based on, when we liberalize, proceeds from the international funds will be able to cover the cost, because the sector, the Gambian market is very competitive, and there are very many players. So to get enough money to pay those loans will be a challenge. So, but the projection was based, government told them, you will be getting the international revenue. So these millions that we are mentioned in the commission were supposed to go to the operators, but it never came. So they have that backlog. So that was that challenge. So they could not translate. So they were paying those loans they've contracted to be part of the EAS consortium. So when it was liberalized in 2016, by the time it was liberalized, the international calls, the value in the market has gone down also. You hardly get a call from international now. You stay for 3 months, nobody will call you direct call from America or UK. Everything is on WhatsApp. So because of so the value of the gateway is now diminished. It has no value. In fact, in the next 2-3 years, there will be no need for the gateway. So this is what happened. By the time when the gateway was relevant for them to invest, they didn't get the revenue. When it was liberalized at the tail end, and there's no value for the gateway now, this is the challenge we are having. So even though now it's liberalized, but they're having some amounts, 120 million is nothing when it comes to in the GSM market, because a base station, a single base station is about $50,000. It is half of that amount that government received in 2020. But when in 2012, it was about millions of dollars. But that time, it was not liberalized, and it was going to a special account at the central bank. So these are the challenges we had. But we recognize the fact that internet tariffs are high in this country, and we are making efforts. But the problem is, by law, it says where there is competition, you cannot do price regulation. But we realize that the market dynamics are not functioning effectively, and they are not responding to competition. So we are trying to put up based on our strategic plan, we are developing a market assessment study that will look at, because that is the power we have. You cannot just say the market is not working, I will intervene. Then the operators can challenge that. But so we look at an independent study that will look at the competition and tell us that, look, this competition is not working. There's oligarchy or there is monopoly, or price, there's price setting. So when that report comes to us, then that will give us the power and the mandate to intervene in the market. In that, so we are looking for towards the end of this year that consultancy will be done, and it will inform us whether the market is functioning or not, and it will give us a recommendation to come in and set the prices. So that's where we are for now.
Thank you. Honorable Fofana?
Just a follow-up question.
Supplementary?
Supplementary. You stated that the gateway doesn't have a value now. But let's look at how it was working before. Before WhatsApp communication, by then all you need is one end. The individual making the call was the duty bearer. He was the one who was paying for the cost of the call, not so. For example, if you're in Gambia now, you want to call Senegal, you just need to have the unit of the subscriber. If you are using QCell, you just have QCell units. The guy you are calling in Senegal doesn't need any credit. With WhatsApp, it's different, which means payment is done at both terminals. You are in UK today, you want to call through WhatsApp in the Gambia, you need to have the network. The service provider there is receiving some fees. You need to have network in the Gambia. The service provider as well is getting fees, which means implicitly they are receiving revenue. So I still believe like the gateway is coming with some advantages. It's coming with some advantages, not as explicit as before. But when you look at the cost, there are revenues coming in. So that question was very relevant. With the liberalization, what improvements is it doing on the tariffs?
Yes, as I said, when liberalization came, we have two challenges. One has to be increase access and also reduce and maybe affordable tariffs. Now, when you open up, and now 3G, we have only in selected areas, and now they want to go across the length and breadth of the country. So they are investing the same time also trying to be affordable. And the market of the Gambia is very small. You have 4 GSM operators plus Gamtel, and all about 5 or 6 ISPs, all competing for the same market. If you look at the dynamics, internet is only available in the greater Banjul areas. And in the provinces, it's a challenge because these are the issues we are having. We want to encourage them to, we said data is now human rights. Everybody should have it. So they are moving to areas where there is no profit, but universal access. So they are moving to areas where they are not making much money, but they are obliged to do so because of universal access. So when you are expanding, all of them are expanding at the same time, and you want to bring in massive price reductions, one has to be compromised. Maybe the quality will be compromised or something, but notwithstanding, we felt that we recognize that it is expensive, and going forward, it cannot be business as usual. We acknowledge the fact that they are rolling on 4Gs and 3Gs, but also consumers also need to have affordable services in the country. And that's why we said we are doing a study to look at the market dynamics and determine that, to say it's not working, we have to intervene and impose certain penalties on them to give us the mandate to set the tariffs. But as we speak now, the law doesn't, you cannot just jump and say it's high out of the event. You are guided by the law. And that law says where there is competition, there should be price regulation. This is why it's different. If NAVEC wants to increase their tariff, they have to come to us. It's a monopoly. We have to set the tariff for them. And this is why even petroleum do the same thing. Pura sets the tariff. So government sets the tariff. Electricity and water, Pura sets the tariff. So, and for Gamtel, which is a monopoly also, government sets the tariff. They cannot change their tariff without coming to us. But for mobile sector, across all over the world, its price is liberalized and it's competition. So you allow the market forces to determine the price. But where there is a failure of that market, then the authorities are duty bound to intervene and address the situation. And to do that, you need to have an independent study to look at the market. And determine that, well, this market is not functioning, it has to be addressed. And that's what we are doing. So the consultancy has already been, the consultancy firm has been recruited, and we are in the process for their first mission to do the market assessment study. And that will give us the authority to intervene and set the price. But as you said, if you look at the volumes, the quantum of money you are talking about, you buy data maybe $50. If you are not on social media, you can, just for WhatsApp, that call may last for 3-4 hours. But for international call, a tariff is just about, to call Senegal now is about $20 per minute. You cannot compare that revenue to a data, whereby WhatsApp, you can be on WhatsApp call for eternity, and how much you pay is about $50 or so. But for international call, every minute is about $22 per minute to call Senegal now. So the volumes are different. That's what I'm saying. But obviously they're getting some revenue because there is an uptake of data. People are subscribing to the internet, but it's basically in the greater Banjul area. But the broadband services, which is very critical for national development, is about 10,000 subscriptions as we speak. That's about less than 5% penetration. What we have is mobile broadband. But the physical disconnection to homes, which is where you can do meaningful work and even transactions, that's about 10%, 5% penetration, which is very, very low in this country. And it's also just within the Greater Banjul area.
Just the last question on the issue. Thank you very much. We haven't reached the issue of price yet. What we are seeing here is you have a shift in policy. Initially, the government of the Gambia was not giving the GSM companies their fair share of the gateway value, not so?
Yes.
Before you shifted to the liberalization, there must have been a need.
Okay.
There must have been a need. An assessment must have been done. So what we are asking is, based on that assessment result, what other dividends will it give to the service users? Those are the ordinary citizens. Because look, the GSM companies have started getting something that they were not having before. You've opened up the market, you've liberalized it, they are having additional income. That additional income, is it going in as a price reduction for the consumers as well? And if not, why? That should be known. Because whether it was good or whether it was bad, but previously the entire revenue was going to the state. Not so?
Yes.
Now the state have agreed. They have opened up the market. Part of that is going back to the GSM companies. So what are the citizens benefiting from it? This is the question we are asking.
Yes, as I said, maybe there's benefit. What I'm saying is that if you look at the Gambia, you have 4G rollout. I think we are one of the countries that started rolling out 4G technology. If we went ahead of most of these advanced African countries, we also 3G penetration is about close to 70% now. Which is, as I said, they are rolling out services to unserved areas before, and also the ISPs are also expanding. So, and to do this expansion, you need to generate your revenue to be able to expand. Maybe if you are starting a business, you can have equity financing. But once you are in, for expansion, you need to generate money to be able to expand. And we've seen massive expansion. If you go to your constituencies, you'll see massive expansion of communication services. From the last track we did, we are for GS for 2G is about 100% coverage. 3G is about close about, I'm not the technical director, but it's close to about 75% coverage. 4G is also coming up. So there is massive investment. They are all competing for access. So when you are on access and you also want to bring price reduction, that's what I'm saying. The priority now is for access. But we recognize that if there is access and it's not affordable, it's still going to be a challenge. And this is why Pura said, you look at it, do a market assessment study and intervene in the market without compromising their access principles. Also, the services also has to be affordable. That's what I'm saying.
Thank you.
If you're okay, I just want to add one. You're fine?
Yeah,
okay. That's fine? Okay, then it's okay.
In the management letter, one of the issues that was raised senior members of the management. This was a concern raised in the management letter, particularly in the month of January and February 2020, that the senior management, there is no evidence of the senior management receiving and signing the payrolls regarding those 2 months. And they did indicate that the implication of that would be a cause of error and irregularities that may not be detected. And the recommendation that was advanced is for the management to ensure that the senior management are in receipt of the payroll and signatory to that effect. However, the management responded that for the month of March 2020, the finance and admin director was the one who prepared the payroll, and then onwards, as at now, the Director of Human Resources and Corporate Affairs prepare the payroll and received and signed by the finance and internal auditor. To that, it appears there's a kind of response according to your management comments that in the month of March, the default is pertaining to the month of January and month of February, that the senior management is not in receipt and signatory to the payroll. The response is indicating that from March onwards, the Director of Human Resources and Corporate Affairs, as well as the Finance and Internal Auditor, are in receipt and signatory to the payroll. Whether in your governance structure, do you consider those two as senior officials in the management?
Thank you, Mr. Chair. Yes, Mr. Chair, the senior management starts from managers upward, so all directors are part of the senior management. Just to clarify, this affected only 2 months, during which period, as you know, with payroll, it's a very delicate balance. But the money issued and you think is finance. So the gray area, the best practice is that when it comes to payroll, it has to be generated from HR. This is in order for them to be sure the staff has come to work, the staff has actually, the dates of commencement and all the matters relating to the staff are inputted properly into the payroll before finance generates the payment. The problem we have currently is because we don't have an enterprise resource management system. We have a standalone in finance and a standalone in HR, and we are trying to make the two talk together, which can only happen when we develop our systems into an ERP, which we are currently doing. But this hiccup only happened for 2 months, and it was corrected when we put the right department in charge of the payroll preparation, and then the authorization is done by the senior officials to ensure that it is approved. And this, in 2021, you won't find any month whereby the payroll has not been authorized and endorsed by these as well as the internal audit. Thank you, Mr. Chair. Let me give the HR director to maybe give a history of what happened. But I can just say that these things are a thing of the past and that they have now been properly addressed. But since he can give a synopsis on the history, why that happened.
Thank you, Honorable Chairman, and use the opportunity to thank all the appointed members here. That the job descriptions exist for almost all of these copies, though some were not in the personal files. And after the auditor's query, we put them all back to the personal files, and those things were adequately addressed. And with certificate of character at that time, it was mentioned to him that the service rule he was looking at, that gift provision, came into effect in 2017. These people were appointed in 2005 or 2006. That's 10 years or so ago. And at that time, it was not a requirement for them to have those certificates that if you have been employed. And I think we have adequately raised those things, those issues with the auditor. Yeah. Yeah, 2017, when the service rule was revised, it was mentioned that when somebody is being employed, he should provide those things. But these people were already on the employment for over 10 years.
Members are going through concerns that are raised. I think the other area of concern is the issue on governance, that the following board-related matters reported by the external auditor should also be addressed, and there is without delay. That the lack of TOR as required by the Act, lack of meeting stipulated number of prescribed statutory meetings were indicated, no special board committees created, management letters not discussed and approved by the board, no evidence of presentation to review by the board departmental activity reports. As far as governance is concerned, these are issues that were highlighted and expressed as concern to the auditors. I want the DG to take us on to that.
Thank you, Mr. Chair. Maybe the chairman would want to say something before I do, if you don't mind.
Thank you, Honorable Chair. I think some boards in the country go by what is in their act, and we've discussed on several occasions whether we need not go beyond what is just stated in the act. And Pura is peculiar in the sense that you have the Pura Act, but then you also have other governing acts which regulate the operations of Pura, because there are certain areas where the management works closely with either energy or ICT. And these are issues that we will have to look at very carefully in the revised Pura Act. Regarding meetings, I think this was 2020. during the height of COVID-19. In fact, there have been instances where we set a date to meet, and then a staff is supposed to travel and go through the COVID test, and we discover that the staff had COVID. And in fact, there were 2 occasions where the whole office was closed and fumigated. And what we had resorted to was operate on the basis of walkabout resolutions. Maybe these were not properly reflected in the minutes that the secretary was supposed to provide to the auditors. It's a very small board of maybe 5, 6. Well, if you include the ex officio, but the others are just 5, and we've considered on several occasions of setting up these specialized committees, or if we have to consider certain items, we constitute ourselves into a committee, a specialized committee, and then come back to the full board, which I think we've started doing. There are certain issues we constitute ourselves into a specialized committee and then come back and report to the full board. But it's a point worth taking into account. There is evidence that auditors' observations have been implemented over time, and I think when we looked at the draft submission of the external auditors, we did ask management what happened to the records of the board considering audit queries and the actions taken, and they did promise that they will bring this to the attention of the external auditors. Maybe the DDG can, if you have any additional things to say.
Thank you, Mr. Chairman. Mr. Chairman, as the chairperson of the Pura board has stated, some of the conflict we have is in relation to developing TORs that does not comply with what the Act of Pura has. So the board has looked into the matter as recommended by the auditors, and they felt the view that we need to update the Pura Act and the ICT Act to reflect what is needed by the board, so that there might not even be a need for the TOR if the things that need to be done are captured effectively in these acts. But developing a TOR that does not, that comes into conflict with what the Act states would be a danger or anomaly. So the TORs are useful, but because we are now high into the Act revisions for both Pura and the ICT Act, it was thought that it would be wise to have it incorporated inside there. Like the chairman said, on the board meetings, there were some meetings that they did virtually, and walkabout resolutions were also done whereby board documents were sent to the members because of the pandemic situation and the difficulty of convening a meeting. So that's why there were a reduction in the number of meetings. This is no longer the case, and now that the pandemic is almost over, we have got back to the routine, and minimum meetings are taking place, and sometimes even more than once in the quarter. Subsequent reports of Pura will show evidence of that. Also on the recommendations of the auditor, like the chairman has stated, without repeating his words, we have also initiated, and currently as we speak, when the board is meeting, if something relates to a particular directorate, that director concerns comes in himself to present the report and to defend whatever is being presented. Unlike before, when the Director General just sits in and presents on behalf of the directors. This has been changed, and we have now ensured that directors are there to answer and also to present to the board. These were the things that are highlighted, but have now been taken care of currently. And as we speak, the current board is operating in that situation. Thank you.
reduce the fine, the administrative fine that was $500,000 was eventually reduced. I wonder why. If NAWIC partially comply to the directive given by NAWIC, and yet still they came to appeal for their fines to be reduced, the authority accepted that. That sounds very funny, and I would like the chair to explain that.
Thank you, Honorable Chair. And as you might have known from the previous intervention by Pura, the Director of Economic Regulation, NAWIC is a public entity, and I think we've always been accused of being soft on NAWIC. But like the DG have said, the difficulty with NAWIC is you cannot shut them down. Continually flouts our rules. We can resort to one, fine them and insist that they pay these fines, and if they fail to pay these fines, it gets escalated to a point where their licenses could be revoked or could be curtailed. But with regards to NAWIC, this is a challenge that we have, and it's a continuing challenge that we're going to have. I think in our previous submissions here, we have asked the committee, the Honorable Committee, to intervene on our behalf to help to see how we can actually ameliorate this. We've gone to the levels of speaking to ministers of state to intervene, because what we don't want is to be seen to be fighting with NAWIC as opposed to actually regulating them. In regards to the fines that we are doing here, there's a term that we've used called supportive regulation, is to actually encourage NAWIC to come on board. As we speak, if you are finding a particular operator, you expect them to pay. If they don't pay, you fine, you curtail their license. We cannot do that with NAWIC, unfortunately. So what we do is to see how best we can collect these monies, and we try to do that the best way that we find possible.
Yes.
Partial compliance.
Yeah.
Now, what effort the public,
yes,
and the issues that were raised, yes, regarding the treatment of the,
yes,
the plant,
yes,
I think are equally public concern.
Mm-hmm.
And if NAWIC is not compliant to that, mm-hmm, what effort have you made to ensure that they comply?
Thank you, Mr. Chair. Before I hand over to the legal person to give a better synopsis, I just want to say that with some should have stated with most, because it wasn't some. There was most of the issues were resolved. There were still some that were not, but the main critical ones were resolved. And as we speak, most of the issues regarding the water quality and all of that has now been resolved. We have a working timeline that we set up with NAWIC. We started with them before any institution this year and set out a timeline agreement. We brought them in and we said these things have been outstanding for this length of time. We want it resolved by this time, or we will resort to fining you and there will be no negotiations. And we've seen them accelerate the way they deal with our issues because they see that we are taking a tougher stand. I think in relation to what we did in encouraging them to come on board, especially in ensuring that they don't fail on things that we agreed with them, is to find a carrot and stick approach. But it seems to be working because they are delivering on most of the things that we have assigned for them to do. In relation to why it was reduced by 50%, I think the legal person will explain to you, or finance, because there's a rule on ensuring that they are paying, which kicks in that daily rate of 25,000. It's heavy. So we find a way that if you fulfill the requirements and things have been restored, at least most of the issues, then there's a chance for us to waive that element of the fees. But finance wants to speak before the legal so that we can clarify better. Or he want a rejoiner? Sorry.
Yes, just a quick rejoiner. It's Honorable Chair, we're not taking chances with the public safety. The reason why we are actually considering the 50% reduction is not that they have not complied. In Bansang, it was to do with salination that they have to do at their plant, because there was some contamination with the water. They have to do treatment that they did not do. But the insistence was that actually took place, but the fine remained. So the fine was in consideration that they have complied with what we've asked them to do. And with regards to most of the water quality that the public is exposed to, we do a quarterly report that we paid for what we are doing in collaboration with the water resources, where every quarter they do a random test of all water points to make sure that the drinking water that the public is exposed to is safe. So we do not take any chances with that. If it is related to that, there will be no reductions. But it's after the fact that we have made this consideration. Thank you.
A little bit lenient with NAWEC. Yes, it's a monopoly, but then it's a service, and also being a monopoly, ones that we depend on electricity and on water. So if you give them that leeway to be flouting your laws and you not taking action because they are the only suppliers, then I think they will continue doing it. What we need to do is to make loud noise, name and shame, make it public like you've done with Comium. When that was done to Comium, obviously they came out and they tried to prevent it from happening. I think that must be done with NAWEC. They must be taught a lesson so that they will comply, because they will have it in their mind. The Director General mentioned that they don't discriminate, but I see this as discriminating. You're saying that you don't discriminate between public and private companies, but this is sheer discrimination. It is blatant. You are giving them a light treatment because you assume that they are monopoly. But they are monopoly, that is the more reason why they should be tough on them, because we only depend on them. If NAWEC should crash now, there will be no electricity or water in the country. So I think that is the more reason why we should be most hard on them. So name and shame them, because as far as we are concerned, people don't know what's happening. Make it public.
Okay, thank you. Just listen to the penalty that was charged to NAWEC, because they were most compliant with some of the penalties that $0.5 million is in total, but because of the compliance that they made in most of the areas, so it was agreed to reduce it to 50%. So they paid 1.7 million upfront. Thank you.
Thank you. Yes. Yes, the total fine is 3 million. Mr. Chair, I just want to reassure the honorable member that we take note, and definitely in the past, I think the institution was a bit soft on NAWEC. They did their best though in naming and shaming them many times. But you know, there are some people here, naming and shaming doesn't even bother them. We have to find a mechanism, and I believe the mechanism we are using is working, because for the first time they came and paid a lump sum to Pura for regulatory fees that they have been accumulating for years and are paying the arrears as well. But when it comes to enforcement, in terms of the quality and the services that they deliver to the public, I want to reassure the honorable member that we are not in any more accepting the games that are being played, and you will see us getting tougher when it comes to public institutions, because as he said, they are monopolies, and for that reason they have public money to run and they are being paid. Therefore we are supposed to be harder on them. The enforcement issue, as we have explained, depends on how far we can go with the enforcement. But fortunately the government is not giving us any headaches in terms of how we deal with NAWEC, and I think that there will be a change. There's already a change in terms of how tough we are getting on them, and we'll get tougher as you have requested. You will see the difference, and there has been improvement in some of these things you saw reported in 2020. We've taken them on board and given them deadlines, and they have resolved them. Even the water issues, we are about to open, formally open a water treatment issue that was almost years not done and not resolved, but it's been done within 3 months, and now we are going to have to go and open that for the people of Gunjur. So there's improvements, in the past, yes, I agree, the softness was there, but we are going to change going forward, and we've started. Thank you.
Yeah. Thank you, Mr. Chairman. I think it will just be a supplementary question to the issue raised by the honorable member when it comes to NAWEC. We all know NAWEC is a public institution. It's a public enterprise. So I think the way Pura treats private entities should be different from the way they treat public enterprises. Now, let's look at the issue of penalties. If you charge NAWEC penalties, it could be, in fact, the individual staffs there would not mind, as compared to a private company whose sole intention is to make profit. If you charge official, for example, today, the owners would feel the burden, they will come after management, they will come after the board, and they will make sure that remedial actions are taken. But who feels the pain when NAWEC loses money? It's the citizens. So for me, I believe over and above charging penalties on NAWEC, individuals should be sanctioned. Naming and shaming them is not where we should stop. These are public enterprises. And besides, if you look at their books, one, they are not making profit, and two, again, the services they are giving to the people is not good. So you are there on making sure that you do the performance assessment with regards to the quality of service they are supposed to deliver to the people. So my question here would be, when you do that assessment, do you go the extra mile to know where the deficiencies lie and assign responsibilities to it?
Thank you, Mr. Chair, and thank you, Honorable Member. Yes, Miss Honorable Member, we do, and I think that's the way forward that things are going to change, and I tell you why. The government has now gone to the point of having a performance agreement with NAWEC itself, with deliverables and timelines, and also reward schemes when they do better. And this is something that Pura was party to, so that we set proper standards for them. This is new, and I think this is the way forward where we can measure what they are doing as per what the targets are in terms of NAWEC. But in addition to that, I think maybe your same committee will be dealing with maybe members of the ministries, because the regulator has a limit to what it can do based on only the services, the quality of services, and the deliverables. But the NAWEC is under the Ministry of Petroleum and Energy. In terms of service, in terms of quality, in terms of access, it is the responsibility of the minister to make sure that those are provided and are available to the general public. And those things would bear on how we as the regulator have a standard that the ministry and the government agrees to, and we monitor to observe and ensure that they are abiding by what is laid down in those performance contracts. So we do, and I am telling you that now with the change of operations and with us having a performance agreement that the government stated that they require from NAWEC, there will have to be ways and means to change them. If from what I discern in the short time that I've been in Pura, there are two reasons for NAWEC's main failures. One is capacity. They had a big deficiency in terms of staff, in terms of competent people that are in that institution. So the number of staff, the quality of staff, massive deficiencies. They are trying to address that. Also in terms of resources, because what NAWEC has been doing is paying debts and investing in all equipment. They have never moved forward to change the scenario or alternative energies. So these are the modern things that needs to be brought to bear, because we have a lot of energy out here in the Gambia instead of the normal energy that we are using out there and incurring huge cost on renovating and repairing these archaic generators when we have a lot of sunlight and renewable energy. So these are some of the things that I think if they move to that direction. And also we at Pura, in the past, there was a restriction on licensing other operators, even for renewable energy. But for the first time, we have licensed an operator to run a renewable energy plant that is off-grid. It was impossible to think of that in the past. But this has enabled a particular village to have power that never had one before. And if we go that way and enable private investors to come, who are keen to come into the market and can deliver the service at quality, then there will be a change. We hope this is the trend, and we are trying to put that into bear.
Yes, but on a separate matter.
Okay.
Okay. Thank you, DJ. I will refer seeing the fixed assets. So the concern here is, if you look at the total fixed assets of Pura, it stands in excess of 43 million. And if you look at the cumulative depreciation value, is in excess of 38.6 million. That gives you a net value of around $4.5 million. So the initial question will go to the finance and admin director, okay, which will be one, how do you charge depreciation on the fixed assets? Is it on the cumulative cost or on the cost of individual items?
Okay, thank you. The depreciation policy for Pura is I'm showing page 17 of the report. Audited financial statement. It shows you the depreciation rate for the different items.
I saw that. What I'm asking is it on the cumulative or on individual items? For example, if you take motor vehicle, right now, if you go to page 25, you will realize that the total cost of motor vehicle is 10.3 million.
Yes.
This 10.3 million is the total cost of individual items. So now, method whereby individual assets are charged depreciation, getting to this total.
No, page 20. No, let me just answer. Okay. Okay. Fully depreciated, but they are still there. They are there. But we charge the depreciation on the acquisition of the assets on the usable lifespan of the assets. But some of them are still showing as the fixed assets. They are showing there as at the cost, this thing, but it's not yet disposed of.
Chair, with your permission,
can I help?
I will go to the external auditor, then I can come back to you. Okay. If you permit me. Okay. I will ask this question to the external auditor. Assets.
Thank you, Honorable Member. Depreciation is calculated on individual assets. There is a fixed assets register where these depreciations are tracked. Based on the accounting policies which are disclosed here. This is a report which aggregates and discloses and presents it in such a manner. But depreciations are done on individual assets.
So now the question would be, with a total cost of over 43.2 million,
yeah,
and accumulated depreciation of 38.6.
Yes.
If individual verification of those fixed assets are done,
yes,
there could be possible variations, so that right now you can know the carrying cost of those assets. Because if you look at the status of Pura right now,
yeah,
it seems like they're running out of fixed assets. And that would not be the actual situation. Let's look at the computers, for example. You look at the computers, it's in excess of 18.5 million.
Yes.
If you look at the accumulated depreciation, it's over 17 million.
Yes.
Which means the net book value of those computers is 1.5 million.
Yes.
This is the literal book value.
Yes.
But have we done any valuations to know the current value of those items, of even some of them which are fully depreciated, so that we can recognize them in our books again?
Yeah, revaluation is optional. It's not mandatory.
Yeah.
If the organization so desires, they can do a revaluation. It's optional, so it's not mandatory.
I stand to object. I would object that right now, if you fully depreciate a laptop computer that costs 35,000, it have passed its useful life, but still now it is good, it's in good shape, and it can benefit the organization. You decide to take it off from your books. What are you doing? You are increasing the risk of it being missing because the organization doesn't recognize it again. Whereas if you revalue it, of course it is coming in as a non-cash receipt, but based on the usefulness of it to the organization, it is going to spare your cost and then work on the healthy balance of your fixed assets register. So we cannot disregard the issue of revaluation. We must recognize assets at their cost if they are fully depreciated and still now they are of need to the organization and they are their operational lifespan is not fully utilized. We have to recognize them back in our books.
Thank you. Honorable, can I help? Can I clarify?
I just want to clarify that with the auditor because he's the one who is going to advise you. Based on his advice, we'll move. When we are ready with that, we will come to you.
Okay.
So, Mr. Auditor, can you advise us on that? Why do you feel like the need is not there to do any revaluation?
If you take computers, for instance, their lifespans are very short. The lifespan of computers are very short now. It depends also on the replacement policy, but like I said, there is no accounting standard which will force you to revalue. Revaluation is discretionary. But when you commit to revalue, then that class of asset you must revalue, and you must stick to that pattern of revaluation, which is done 3 years minimum to 5 years mandatory for any class of assets. If they so decide, they can revalue. As far as the audits are concerned, as long as assets are not misstated, we don't have a problem.
Now, the final question to you will be,
yes,
how do we ensure that they keep track of these assets which are fully depreciated in their books, but still useful to the organization?
What we do, we check to ensure they have a comprehensive fixed asset register, comprehensive in the sense that the assets have tag, they have number, the locations are there, and then these are periodically checked. Like a verification is done to confirm their location and condition. That we do. We also liaise with internal audit based on the review that we've done in internal audit to see whether they have done any work on that. But we check to ensure that fixed asset has a comprehensive register and the assets are verified at least minimum once every year. If we don't see, then we report.
So, no, I'm left with two. It's not exhausted because this is a critical area. Not really, Mr. Chair, you allow me, because we are looking at fixed assets at a total cost of 43 million. And the accumulated depreciation on those fixed assets is in excess of 38 million. And we don't know whether these fixed assets still now are in the organization or still now they have some carrying value. That is significant. So the external auditors have said we are maintaining a fixed assets register. So to the accountant, how do we maintain our books? Do we have an accounting software or are we maintaining them manually?
What the fixed asset register is on Excel sheet, but the categories of assets that are bought by the institution.
Now I would go back to the external auditor. The fixed assets register is maintained on a manual sheet, on an Excel sheet.
Yes.
An Excel sheet have an accounting software whereby by the rights, user right level, by the authorization level, someone will need authority to be able to what? Alter whatever was inputted in the system. This is an Excel spreadsheet. So how do we make sure that our fixed assets register, in the absence of valuation and recognizing those assets in our books, how do we make sure that the assets of Pura are safeguarded against any potential risks?
being in Excel does not necessarily mean that everyone has access to it, because the access rights you build in native system, you can still build those access rights in Excel. It depends on who is utilizing the Excel. But the fact that they are in Excel does not necessarily mean that everybody has access to it or people can tamper with it.
External auditor, why I'm asking you is, you have the responsibility to assess the risks which the organization are exposed to and give them advice with regards to remedial measures altogether. If at all we all think the way you've alluded to, there will be no need for evaluation. No, it's a dialogue. I want to lay the foundation. Can I learn? Let me just finish. Mr. Chair, the issue here is we need to be straight with the situation. We can make it open-ended and leave it as it is, and that would not serve anybody's interest. We all have responsibilities. Our responsibility here is to get the system as it is. Not so. That is it. Now we know how the system is, and it is someone else's responsibility to highlight those risks altogether. So what I'm saying here is, it is the responsibility of the external auditors to highlight the risks associated in the system. Fixed assets are fully depreciated, but they are still of value. They will only be of value if at all the organization has security over them. The system where they are kept is not secured. So now the question is, what do we do? 38 million fully depreciated. There can be items lying down. So I will still go to the external auditors. Can you properly advise us with regards to the risks associated with that, and what remedial actions do we take? I'm sorry if at all the question was hard, but I strongly believe it's a cause for concern, and we need to come up with remedial actions. We cannot leave it open. Yes.
Yeah, what I was telling the honorable member is the fact that something is in Excel does not necessarily mean that the controls are super weak. No, there is a there is an accounting package which is QuickBooks, which they are using. In the QuickBooks accounting system, you have all of these things in there listed. Then you also have a comprehensive assets register, which is maintained in Excel, which we check to ensure that what they have in Excel reconciles with the ledger. The depreciation calculations are done. What he is saying regarding usefulness of assets, yes, periodically fixed assets are supposed to be looked at. Every reporting period, you assess the useful lives. If necessary, if you think you need to revise it, you revise it. But even if you revise it, you will still depreciate it. When you depreciate it, some will have zero net book value because you have exhausted their useful lives, for instance, but they may still be in use. If you so desire, you can revalue. But revaluation is optional. That's what I'm trying to say, it's optional. But we've noted that. We've just not reported it, but we've noted that some assets are fully depreciated.
I was trying to help with that aspect so that the honorable member can, as we have rightly pointed out, the case to determine in terms of whether the validity of the assets are there and correctly stated or not. As the auditor has stated, they've come in from previous auditors. So the asset register is there from the previous auditors as the closing. And when they start, they have an opening balance which they validate by verification exercise to ensure that the assets exist, have been tagged, labeled, and they are in the location that they state it is. That's the first part of existence. The second part is the value. The value of the asset and determination of the value depends on the policy that it states. It will tell you if it is 25 years, you depreciate over this number of years every year, or if it is 5 years, that's what you do. But management as a whole has the responsibility to look at assets that are still inexistent in the institution, which the institution is using, that are at nil book value. And if they are being used or expected to be used for more than 1 year, according to the international accounting standards, then a revaluation has to be done. A valuer is called in to assess and value the asset and reinstate it into the books at the valuer's rate and not the net book value. We are looking into that for assets that are at nil book value, and we have replaced a lot of assets that you are seeing here as having a valuation of nil already. Those assets in our current books would have been either sold or disposed of through the rules and regulations of Pura, through an auction or whatever. But yes, you are absolutely right in the sense that having an asset that exists, and to allay your fears, we are also transitioning into an ERP, as I told you, which would be better than what we have currently in our Excel methodology. The QuickBooks is good but not adequate.
With a case in hand in this company, where fuel values were maintained on Excel and the values that were given to the board were misleading. Because anybody can tamper with it. So if you see fixed assets values of 43 million and an accumulated depreciation of 38 million, and you know that some of those fixed assets, their useful life is not yet completed, you really want to know where they are being kept in the organization. So, Mr. Chair, if you would permit me, I would urge this committee to request for the printout of that fixed assets register for the retention of the committee. Thank you.
Request for the printout of the fixed asset register to be made available to the committee.
Absolutely, we'll deliver that. Thank you.
Activity report. Had been raised by a community that is precisely Gunjur to the authority, and the authority acted on that. NAVEC was engaged and they did confirm the situation and said they were working on finding a solution to the matter. That was since 2020. What is the current position regarding the situation of the water quality of that particular community that was lodged to your authority since 2020?
All right, thank you, Honorable Chairman. Yes, a complaint was received by the authority through our usual consumer parliaments, where one of the water looks red. So it's not something that they were using, they were drinking. As you know, at the authority, we take complaints not only by individuals, but we can take community and class complaints. We have taken this complaint and we've been working with NAVEC, like you said. Incidentally, tomorrow was supposed to be the presentation for the completion of that particular project. We've worked with NAVEC. They have diverted the water supply for Gunjur from Nyofele to Gunjur. Now they've done some civil works where pipes were laid and water is now routed to Gunjur, and Gunjur is now not suffering from the contamination from the water that they were receiving from there. Because what happened is in Gunjur, I think, where the borehole was sunk, there's an issue with contamination, is where they had this iron in the water, and it's what was causing the discoloration, and they were not drinking the water. So all works have been done. As of today, we are supposed to do the presentation at Gunjur. I think
that will enable a particular operator to build a petrol station in a specific area. So based on those requirements, we have our regulatory tools. One of the regulatory tools is a site screening checklist, which since the regulations were developed, is what we used. If somebody is interested to build a petrol station, that's the first requirement you have to meet. So part of that requirement is the station should not be within a public place or residences. So this is what was used, but the challenge there is, before the regulations, we have existing stations. So what we do as regulator, those stations, we do our best in terms of making sure that they meet certain requirements, particularly when it comes to health and safety, because they already existed before the regulations. So when the regulations came into being, we make sure that all the stations that are built will meet these regulations. So there comes a time in 2021 that those clauses, particularly the one that talks about public places and residences, was amended, and the specific clause on residences was removed. So this gave opportunity for most of the operators applying to also pass the requirements of the checklist, and one of them is jar oil. So initially they were not giving the clearance to build in Wellingara, but because of these amendments, they passed all the requirements and were allowed to build. So nonetheless, during construction also, we have another regulatory tool that we implement, which is a construction permit. So if you are screened and then you are giving the clearance to start constructing, you have to meet certain requirements of other laws. One of them is the requirements for environmental approval and also development permit from physical planning. So all these intervene are processed at Pura and to give you a construction permit. So during the construction, the issuance of the construction permit also, we made site visits where the construction is being done to make sure that you adhere to the specifications of the law, including health and safety issues during construction. So currently, this is what we have been doing. Maybe the DG could also add on to that.
In your explanation, it appears you also confirmed that Jaja was in default of constructing without permit.
Yes.
It is not a requirement. If a company is in that default, there is no need for any penalty to be levied.
It was clearly communicated to him that he should stop construction, and he did. So engagements were done, and he waited until the amendments in the regulation, as I said, were done before he started constructing. You have other stakeholders who also have mandates to monitor, including NEA and physical planning. So all the stakeholders during the construction permit are mobilized to go and also monitor the requirements that they have passed to the operator to adhere to. Yes, there was, but DG could elaborate on that.
Yes, I think, Honorable, you are very right. At that point in 2020, he was in contravention of the requirements for building a petrol station. And when the place was sealed and there was an enforcement, that's when he was fined. I can't remember the amount of the fine which he has paid. Now, and he was asked to stop. But not related to that, coincidentally, at that point in time, because when the regulations were developed at the time, we were very optimistic. But if you want to build a petrol station from Brikama to Banjo, there is nowhere you have a place where it's not close to residences. And in line with best practice in all over the world, petrol stations, they cannot be in the bush. They have to be where people are, but with safety measures enhanced. So this is why the regulations were revised, and the 50-meter front of residences was removed. But for public institutions remain. You cannot build 50 meters towards close to a school or a market or a police station, wherever. So these were the things that are serious. But the residences, we said, is going to be very difficult to have even if you have that, people will still come and encourage near the petrol station. So the act was revised. So when the revision came, it gives him the chances why it was able to complete the building. But at that point in time, in 2020, it was against the regulation and he was asked to stop and fine.
What is the distance to public institutions? From the filling station to public institution?
50 meters.
50 meters. There is one filling station not far from Brikama Market.
No, but
the former cooperative it's not far from the market. Do you have that in mind? The proximity of that station to the market
Yes.
is very close.
Yeah, Mr. Chair, Gambia is a difficult place, Mr. Chair. And it's good to have the facts, because the facts are some of these stations have been built and the people came to encroach to the station. They were built with that distance in place, given the license, and the people permits should not have been given out when we have agreed that this is the mandate and this is the distance that should be there. But just to go on to the point that you stated, we know that one. And even now, we have issues. In that Birkama specifically, the station is complaining that the people are coming, even the sellers, they are building sacks and things to come closer and closer to the station. But the issue is enforcement. Pura can report. And even this year, we have written to the Inspector General of Police and to the area council to ensure that they don't give permit to people to sell closer to the stations, and that they should desist from allowing business people to come closer to the station. We are making some headways, but like I tell you, it's a difficulty in this country when you are tackling the public. But your point taken, the proliferation of petrol stations is alarming. And I agree with you that it is too much, the amounts available in just this area. But the law is what guides us. So this is where now the Petroleum Act, the laws of the Assembly, should now decide and give a requirement that says if a station exists in this place, within 1 mile radius, nobody should have a station. The current rule we have is 50 meters, and that no station should be 200 meters on the same side of the road. But if you are on the other side and you are more than 200 meters, Pura cannot stop you, because the law doesn't tell us to stop you. So it is the laws that we need to amend to ensure that Pura has the rights to stop a businessman from operating or opening a station. Otherwise, with the requirement we have, we just have to approve that they set up their stations. Even if there are too many, the requirement is that they should be 200 meters from each other, not on the side of the road, and 50 meters from built-up areas. This we do surveillances, we send our team around, even for existing stations, to check, and if it happens, those that are not existing, we tell them, no, sorry. We have rejected so many stations. And I can tell you, even we have, at last week, we have Ja Oil rejection for stations that they have bought land and everything ready to build, and we have told them no, unsuitable, because they failed this and this and this on the regulation. And we can submit those lists to you of even this year, how many stations we have rejected. But if the law is not amended, our hands are tied.
It is you who should request for the amendment of those. Move on and request for those laws that are disturbing you in trying to execute what is right to be done. Precisely, let me come back to the issue of the one at Bikama. That is not about encroachment. The new establishment is the filling station. The market has been there well before the filling station. In fact, there is a car park, a taxi car park there. That then later the filling station came. So the issue is not about the encroachment by the vendors. I was asking in relation to the distance in connection to where the filling station is supposed to be built. It should be away from public place about 50 meters. The market is a total establishment. It has been there before the filling station. I am saying the proximity of the filling station of that particular jar oil to the market, I want to believe it's less than that 50 meters or something like that. You need to verify. But the establishment has been there well before the filling station. The issue of encroachment is not the issue.
Right. The regulation of the act came to us sometime, but the market was liberalized before the regulations came to Pura. So most of those stations you are seeing were built before the Pura has a mandate to regulate the sector. So that particular station and the one just when I going away from Brikama, just near that, just before Bottrop, those were built before the act came to Pura. So this is why this is where that. But if it started when Pura was in existence, there was no way that could have been built. Even during construction, teams were going there because we are concerned. It's very close to the market, and also there is a car park just behind it. But the construction started when fiscal planning were only issuing a construction permit, and it was not, the regulation didn't come to Pura at the time. So that must have been the problem.
Mr. Chair, I take note that just for you to know that we are very vigilant, and in terms of us coming to request for what we think is right to do the corrections, we would do so. There are difficulties though, and I want to highlight them so that when you meet those people also, you can bring it to bear. Physical planning are in a total conflict with what Pura's rule and mandate is. They give permits for construction, and they give permits thinking Pura has no right to stop when even it's a petrol station. We have been written to say stop issuing construction permits. For filling stations, it is in the Pura Act, in the Petroleum Act, that it is our job, because we look for things that physical planning would not look for, like safety, like what the regulation and rule states. So I think the alignment of the roles of the various institutions is critical for this country so that things can be done right. Because people think when they have a permit from physical planning, they can go and build. And by the time Pura comes in, they've spent millions building, and we tell them, sorry, your place is not suitable for the station. We're not giving you a permit. So this is why we originally agreed we go as a team. When somebody identifies a site, the whole team that is involved, any physical planning, Pura, we go as one team to assess, and then we all say, yeah, we are happy before you are issued with a license. But now they can go and get a physical planning permit without coming to Pura. If they do so, they go and build, and then they come to us and say, I'm building a station. And we say, no, you are not right. So these are some of the challenges we have. We are trying to ensure that this teamwork that we had before is reinstated and done so that nobody can come and query Pura for stopping them after they have invested so much.
On litigation, there is a lawsuit involving Techwell Oil Company to determine interlocutory by the High Court. It is indicated that the case was ongoing, that is in 2020, at the High Court. What is the fate of the case?
Chair, with your permission, we'll give our legal office, Deputy Director to.
Thank you. Process, external counsels also applied for it to be struck out, and it was granted, and they never went back to release it or anything. So that was the end of the matter. Yeah.
On activity? Okay, yeah.
Okay. Thank you. I would just like to refer you to page 26 of the audited financial statements, notes 9. Notes 9, where we have the receivables. And we will correlate this to the staff car loans on the management letter. But I will start with page 26, where you have the staff loans. Between from the 1st of January 2020 to the 31st of December 2020, there's an increment of almost 5.8 million in staff loan. That is, it started with 4.4 and the closing balance was 10.3. And if you go to page 26 of the management letter, the external auditors did have express a concern. And I will read. It states that during the review of staff car loans, we noted that the staff car loan policy should be further improved to ensure that a joint bill of sales and joint insurance policy is maintained in line with recommended financial practice. So my question is, since we are seeing increments in the staff loans, so I want to know, with the absence of the joint sales and the joint insurance policy, what implications or financial risks is the organization exposed to?
Okay, thank you. This 10 million staff loan is a combination of all loans given to staff. You have building loan, personal loan, and car loan, and maybe 1/6 also all. So it's all combined to this one. In year 2019, Pura didn't started giving disbursing building loans to staff. It was all started in 2020. That's why the figure has increased from 4 million to 10 million. And also in disbursing building loans to staff, they normally bring their documents, their compound documents, and a guarantor is provided for them to for the disbursement of the loans, and it's done by stages. We normally check that the money that is disbursed to you is utilized on the building, and also the documents are always kept with the HR directorate.
No, the question is, we are not substantiating the value. That is in order.
Yes.
Because there is no audit complaint about the value or the increment. The audit concern is about the joint sales and joint insurance policy, which is supposed to be maintained by the organization. And as per the audit observation, it is not yet implemented. So the question is, what financial risks are we exposed to, so that we would know how best to move forward with management with regards to that? Probably maybe the external auditor will be in a better position to explain that.
Thank you, Honorable Member. When you don't have a bill of sale or insurance being recognized two-party wise, you can easily sell your vehicle, and the interest of the organization will not be noted. So that's the risk. The staff can sell the car and they may not even pay.
To the DG, how far away with the amendments on the staff loan policy?
Thank you. We are on the amendment of all policies of Pura, not just the staff one, all administrative policies, because a lot of them have loopholes. And I think they would all be complete this year, definitely. In regards to the loan scheme that we have, just to allay you in terms of the risk exposure that we have, even if the staff goes and sells that car, the institution is covered. How? All loans that we have given, staff signs an undertaking and guarantor. And that guarantor usually is a staff of the institution. So these are long-term staff with pensions and funds available. That is enough to pay any car, for any car. So we ensure that. In the past, we have multiple guarantees by one staff, which I also stopped, because I said to them, the reason we have guarantor is that when we fall back, the money that you have in our coffers is enough to cover the debt. But if you leave one staff with a 2 million in his pension, guaranteeing 10 staff for 2 million, you are exposed to 10 million rather than 2 million. So we have also closed that loophole with our legal office to ensure that the staff exposure and even the guarantor's exposure is adequate to cover it. But the revision of the rules to cater for this joint sale and joint insurance is ongoing and will be done.
Chair. It's over to you. Thank you.
Thank you very much. Before we close, I want to refer you to the issues that you raised on the challenges. Page 30. This was 2020. We are now 2022. And then in page 31, you went further to indicate the way forward. You raised salient issues that should be addressed in order to address those challenges. This was 2020. With your assessment, how far are you regarding the challenges that you have raised in this report in relation to the issues that you highlighted in way forward in page 31?
Thank you, Mr. Chair. I think I'll take them one by one, but very quick to save time. On the low compliance level of some licenses, as you have seen, we have started doing serious enforcements and ensuring that anybody that defaults on their license or on the regulation bears the brunt and heavily and without compromise by the institution. And this has happened in this past year. We have ensured that a lot of them have paid up. Even those that we are slated for write-off, we were able to get the money back because of the impact of the licenses. And we ensure that you are not renewals, are not given automatic. If you are defaulting on either our payments or on the rules and regulations, we can cancel your license. And we will do so that others will desist from this. On the limited level of computerization of Pura systems, we have also engaged the activities of consultants to develop an ERP system. At the moment, we are doing a solution design. We've dealt with the needs of the institution to ensure that all the systems are computerized. For the petroleum sector, we have now created this year an NPIS, National Petroleum Information System, jointly with the Ministry of Petroleum, whereby the start to the end of the licensing process is fully computerized. And everything is online and everything is documented. So whatever is done can be queried by audit and the facts will be there to show. We believe before the end of the year, the ERP system would have commenced so that all the other systems, including our HR and finance, are linked to this. Luckily, we have external funding assisting us on this with the World Bank. So that is making it lighter on us. Item 3, on the awareness of licensees on the importance of Pura work, we have gone on a campaign and we'll continue this campaign, both on radio and on TV, for people to know what is really our mandate, because especially on the online media, a lot of things are blamed on Pura that have nothing to do with Pura. But when they hear regulator, they think we regulate everything. So I think it's important for us to sensitize the public, to go on a real campaign to ensure that people know what we are doing and why and how we can make life better for them and for the organization and for the government. Inadequacy of funding, I think I mentioned partly during the interventions I made. In all fairness, Pura is under-resourced because our mandate is huge. The number of staff we need and the equipment we need can only be done if the funding that we do to get these monies are coming to Pura. All the multi-sector regulators in Africa and in the world collect their license because they put the license together. They do the work. For example, look at what happened in this Comium case. We went on a campaign, made sure they paid, and the money went to the government coffers. Pura didn't get a dime. The only thing we got is our fees for the regulatory fees, not the license. 60-something million went to government. At least Pura should be given part of that to develop and buy equipments needed for that. So inadequate funding will need the help of the National Assembly. We are doing our part to discuss with our line ministry, with this Ministry of Finance, showing that the need for it. Because if we have the right equipment, we'll be able to find the cheats and get more money. Just to give you an example, the operators of ICT used to give us their figures on spectrum usage and everything. And we were obliged to just accept what they gave us because we had no equipment. Of late, through the help of the World Bank, we bought our own spectrum monitoring equipment. So we are able to see and be able to validate the figures they are giving us. The same way at the gateway, we have a mechanism and a computerized system to see the figures ourselves, the movement of traffic, without having to rely on the operators telling us we use this amount or that amount. So it will be a joint thing. Pura can push so much. We expect and hope that the government will realize that the regulator, for it to function properly, like in Rwanda, has to receive its money. And if we have surplus, of course, we can give it to the government to be used for other activities. But the regulator has to resource itself first, carry out its strategic plan before funding goes to the government, and then we have to ask for help. On the availability of enough office, yes, Pura rented an office, which is inadequate for us. In the interim, we have done something and we have got an annex. We have expanded and our new staff are in the annex. This is through our own means and resources. But in the long run, a regulator should have its own office. We have a land given to us. It's not big enough. We have the money. It's not much, but it's adequate to give us some leeway. And we are constructing. We have done the tenders and everything. GPP has passed our tender. Our office, hopefully within 1 year, will be up. And we'll have our own office with all our annexes in one place. So this is in the pipeline.
Thank you very much. I think yesterday we did indicate that GPP is supposed to present the compliance report. Unfortunately, to seize this opportunity to invite them to present its compliance report 2020.
Thank you, Honorable Chair, Honorable Members, Pura Board and Management. Just to be very procurement and our regulatory functions include prior and post review of procurement transactions. When it comes to prior review, these are transactions that are subjected to our review and subsequent approval prior to activities being carried out. And I want to report that Pura has been very compliant in terms of subjecting their transactions to our review and approval before they conduct any transaction. For the post-review, and of course, the post-review would have generated a report that will be presented here. Now, we reviewed them for 2017 and 18, and we wrote to them. A draft report was generated and sent to them, but they are yet to respond. However, our post-reviews include just verification of transactions that they would have conducted without our approvals based on thresholds and so on and so forth. But I also want to report that Pura has been sending monthly reports. They have been reporting on monthly basis on their transactions that are within the threshold. You have transactions of single source and RFQs, which they can conduct without subjecting them to our reviews. So like I said earlier, the post-compliance reviews is just to verify what they would have conducted in case there are transactions that are above the single source or the RFQ threshold and they were not subjected to our reviews. We can just capture them and generate a report. And in most cases, in fact, if they exist, the external auditors sometimes will capture them. But Pura is been scheduled for reviews for the 2020 and 21, and very soon we'll review them. And we are also awaiting their responses for 2017 and 2017 and 18. And once these are received, the management responses are received, we'll finalize, and then the report will be sent to this committee as soon as possible. Left to me alone and GPP, we may recommend that you consider the report without GPP report, which will be sent very soon, simply because, like I said earlier, the final report will be generated when the post-review is conducted, which, of course, they have almost fulfilled part of it because they have been sending monthly reports. And almost all their prior reviews are done and ensure that they are in line with the laws before they conduct any procurement. Thank you.
In your presentation, you did indicate that
yet to be reviewed.
Yeah, and the one that you said for review are 2020 and 2021. I did not hear 2019. That is
Sorry, that is an oversight, but we already reviewed them for 2017 and 18. And 2019, 20, and 21. They will be scheduled as soon as possible.
Yeah, for 2017 and 2018, we are only waiting for the response from the manager.
Yes.
Pura, what do you have to say?
Thank you, Mr. Chair. I believe we received this in the due time that they normally give for response to come. We didn't have enough time because it was, I think, less than 2 weeks that we received it from them. So we are still in line, but we'll accelerate our response to them.
Can you give us a time frame? When do you think you can be able to adequately respond?
I believe we can do this within this week. We can give you the response before the end of the week. Because we, like he rightly put, we have always subjected ourselves to the rules and laws of GPPA. We have no, in the past, had any issues relating to them. Thank you.
Coming back to GPPA, the ones on your decks, 2019, 2020, and 21, they are scheduled to be reviewed. Give us the time frame to work on them.
Offhand, we have a timetable which is all which we are working on, which guide our compliance review operations. And now I cannot definitely remember when say, Pura is being reviewed for, being scheduled for the review. Unless I go back to the office, then I can provide you with the schedules.
You can provide those information.
Okay.
You are already part of EFA, okay. Make sure by our next sitting, come with your timetable. Okay?
Okay.
All right, thank you very much. Honorable members, ladies and gentlemen from Pura, advisor, ladies and gentlemen. Our able clerks, Yesterday and today, we've been engaged in Pura on their reports 2020 activity and financial statements, presentation and consideration. The committee had, together with the able assistance from the subject matter specialists, thoroughly reviewed the reports, and today we raised issues for clarifications that were highlighted by the auditor in the reports, and I can deduce that we had received clarifications in most of the issues that we raised. We still request some documents to be presented in order to satisfy the committee for still clarity, and we still maintain that the authority provide those documents that we requested to be provided to the committee. Aside, as earlier on indicated in the introductory note, the auditing opinion that was advanced, the satisfaction on the audit, the accounts that were audited, we noted that with concern, and we also noted, as indicated by GPP, the compliance, even though they are yet to present, the compliance of Pura in providing their monthly reports to GPA is equally noted. On that, are we resolved to putting the motion back to the committee, either to consider the report or otherwise, as I indicated earlier on? That is entirely the opinion of the committee. And that's for the committee to accept the report or to adopt the report, subject to the final adoption by the plenary. We are obliged to make so come September ordinary session. We are not going to accumulate our reports. Anything that we have, we'll make them available to the plenary. Come plenary, the report on Pura will be before the plenary for final adoption. This is the plenary adoption by the committee, but by the assembly will be done by the plenary. Can somebody from the member or from the committee move a motion to adopt the report of Pura 2020 presented to the committee yesterday and then review and considered? Can somebody move the motion for the adoption of the report? In the absence of no issue, if there's an issue that you feel otherwise, before we move to adopt, somebody can equally do that as well. No issue? In the absence of any issue, can somebody move for the adoption of the report of Pura 2020? Honorable Musa Cham moved that the report be adopted and seconded by Honorable Suleiman Jame. Those in favor, please say aye.
Aye.
And those not in favor, please say no. The ayes have it. On that note, I want to take this opportunity to thank the subject matter specialists, our technical assistants, for the wonderful work that they have done, the Auditor General, the members of the committee, support staff, and for Pura for adequately responding to make yourself available to present your report 2021. We still have institutions that have their 2016 to be laid. If you have met the threshold of presenting your report 2020, I think you need to be commended for that. And we hope and pray when we request for the presentation of 2021, we'll have no complaint or request from Pura for rescheduling of the program. On that, we commend you for that. We look forward to see you in September when we'll be laying our report. The issues that will be raised as concerns in terms of financial management as well as administration, and we hope so you will adequately take note of those issues and improve on the financial management and administration as well. On that note, I thank you all. Can somebody move that we adjourn this sitting? That's the morning, is still the morning sitting until in the afternoon. Those in favor, please say, can somebody move the motion?
Seconded.
It has been moved and seconded that we adjourn the sitting for now until the afternoon sitting. Those in favor, please say aye.
Aye.
And those not in favor, please say no. The sitting has been adjourned. On that note, I thank you.